Good morning. The lawyers who are practicing in family court affairs matter and particularly files diverse persons, they must understand that they have to substantially prove the cruelty. So, for the purpose of how to prove cruelty, a judgment I am now referring, in which there are about 7 cases of Supreme Court and other cases, wherein the several starring examples of cruelty were being discussed. Kindly go through those judgments also, apart from the judgment which I am going to discuss with you, because there were certain observations which I would like to place before you for your rethink and revaluation. This is AAR 2022 Madras 258. This is AAR 2022 Madras 258 and C. Sivakumar versus Sri Vidya. C. Sivakumar versus Sri Vidya. Justice V.M. Velumani and S. Sauntar. Both are the party to the suit. The judgment was delivered by Justice Sundar. Two things have been discussed here. Actually, before that, we should better know the history of the case. The appellant Sivakumar was a professor of Vivekananda Medical College. The Sri Vidya was a teacher. They married 2004. They married, and thereafter one and a half child. The child was born, and the Sri Vidya used to lodge complaints. There were 2 complaints. Both complaints registered by Aluman police station. Subsequently, there were a nuclear life settlement was arranged, but still she was not satisfied. However, she used to go to the working place of Mr. Sivakumar and tarnish his images. However, the HMOP filed before the family court Erode was dismissed on the ground that husband did not prove cruelty with substantial satisfactory evidence. Therefore, the appeal was prepared, that is called CMA, Civil Miscellaneous Appeal against the family court order. For that also I want to remind you about the procedural aspect. The how to substantiate mental cruelty were discussed in several sessions Supreme Court judgment. Finally, the verdict. See, the judge has underlined certain paragraph. However, there may be a case where conduct complained of itself is bad enough and per se unlawful or illegal, then the impact or injurious effect on the other spouse need not be inquired into and considered. So, in such cases, cruelty will be established if the conduct itself is proved admitted. This is verdict of Hobarani versus Madhukar Reddy, AR 1988, SC 121. The judge has said 2 aspects in this case while allowing the CMA and granting divorce. Number 1, they say wife suspecting his character lodged some complaints. They say since they were living separately from 2000 onwards and there is no evidence to presume that there is possibility of a reunion. Then the important thing was that they say removal of thali chain is often treated as an unceremonious act. We do not say for a moment that removal of thali chain per se is sufficient to put an end to marital life, but the said act of respondent is piece of evidence in drawing an inference about the intention of the parties. The act of respondent in removal of thali chain at the time of separation coupled with various other evidence available. So they say there is no possibility of so in light of that the divorce was granted, appeal was allowed. So the removal of thali is, and before that while drafting grounds for divorce, and we are subject to professional ethics that we are not supposed to advise for quickie divorce. No advocate shall advise for quickie divorce. Quickie divorce means immediately issuing notice for divorce. You may say that there should be some attempt to reconcile the matrimonial tie, and if failing with legal process will be taken. That should be your call in the legal notice. Kindly mind that it is up to you to decide what the procedure you have to follow. Therefore, at the time of drafting, you have to state everything in the legal notice about the cruelty meted out by you. And at the time of filing divorce, you have to you get collection of evidence and substantial evidence by examining witnesses about the cruelty meted by the either spouse. So kindly take note of all these cases. This case is most important for the family court lawyers. Best wishes.